Justices of the Appeals Court, now sitting at Boston for Jim and Pona, Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Is that on? It seems to be. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Shin. To my left, Justice Hodgens. We will be hearing 5 cases this morning. The rules are, as they always are here, 15 minutes per side and no rebuttal. You should let us know at the outset if either side will be dividing time among various parties on that side. We've read your briefs and are familiar with the facts, so my recommendation is to just start in with your argument, but it's just a recommendation because the time is your own. And so we will hear first this morning, number 23907. I note that it's a partially impounded case, so I assume counsel are familiar with the impoundment order and will adhere to it. And it is Commonwealth versus Vieira. We will hear from Attorney Us.
Good morning, Your Honors. Justice Rubin, may it please the Court. My name is Attorney Adam Oos for Carlos Vieira. Mr. Vieira asked this Court to reverse his convictions because violations of the first complaint doctrine and the use of improper opinion testimony by 2 state troopers resulted in a substantial risk of miscarriage of justice. With respect to the first complaint testimony, Aunt Lisa's testimony violated the first complaint doctrine because she was not the first complaint in this case, and the Commonwealth did not provide any justification for substitution. The record clearly shows that the cousin, in this case, was the first complaint.
The record doesn't clearly show that.
If you look at, it does, Your Honor, the suppression motion in this case on page 13, Sergeant Bucari was asked whether the complainant in this case told anybody about the, I think she referred to it as the encounter, and he said that he confided in his cousin in October.
That's the hearsay statement of the police officer, is that right?
I'm sorry?
The hearsay statement of the police officer at the motion to suppress is what you're referring to?
That's correct, yes.
Okay, and then we have the testimony of the actual defendant who is asked at one point whether he told anyone before this, and he says no. But that's not even my point. I'm not saying he's telling the truth or that that was fully explored, but without knowing who the first complaint witness is because of this ambiguous testimony, what are we supposed to do?
My point exactly, Your Honor. This was something that was supposed to be resolved.
Then maybe counsel should have objected, or maybe you should bring a motion for a new trial so that someone who can make a finding of fact can determine who's the first complaint witness is.
That would be one way to go, I suppose, Your Honor, yes.
How can we do anything else if we don't know who the first complaint witness is? There was no objection below, and I believe the prosecutor even said something like, we think this is the first complaint witness, but if we discover something else at trial, then we may change this up. And counsel said nothing. I mean, for all that appears in the record, counsel agreed with that, defense counsel.
That would be why reversal of remand would be necessary in this case, because nobody did what they were supposed to do.
If the actual first complaint witness testified, everyone did exactly what they were supposed to do.
But she wasn't the actual first complaint.
How do you know?
Well, in addition to the suppression motion, there was also evidence, or at least there were statements at trial. The Commonwealth, during their opening statement, and I know it's not evidence, but they did announce to the jury that Destiny, the cousin, blurted out something to the effect of he's meeting men when she was trying to deflect for herself. So
and that means that he complained to her about that?
I'm sorry?
She said, look at his phone. So maybe she knows he has a Grindr account, but that doesn't mean that she heard this incident.
Well, case law is very clear that the judge has to make determination as to who the first complaint is. And where you have conflicting testimony or conflicting indication to who the first complaint is, a voir dire would have been necessary to make that determination. And certainly if the Commonwealth knew that there was some ambiguity about who that first complaint witness was, they are required to justify why that is not the right person, that person was unavailable to testify, too young to testify, as in, I think it was Thibault, which was a proper, let's see here.
Well, while you're looking at that, let me just come at this from a different angle, slightly different angle, because on page 23 of your brief, you wrote the onus was on the trial judge to resolve these issues. So I'm trying to put myself in the position of the trial judge here, and it's a substantial risk of miscarriage of justice standard that we're looking at. So I'm trying to understand what the error of the trial judge was here, because the only evidence before the judge was the victim actually denying that he told Destiny what happened to him. So how is the judge supposed to figure out from that there's another or multiple other potential first complaint witnesses lurking out there that he's supposed to figure out?
Well, prior to the complainant's testimony, the testimony you're referencing, mother testified. And mind you, at the start of trial, the Commonwealth said this is not crystal clear, this could change. During mother's testimony, trial counsel objected to mother's testimony, you should check your phone because, and at that point he objected. During that exchange, I think it was pages volume 2, 43 through 47, the judge said, I thought Destiny was going to be your first complaint. And the Commonwealth said, no, that's mother. So the judge had some indication there that there was somebody else, particularly the cousin. And under those circumstances, even before we got to the complainant's denial of having told anybody, the judge should have explored that in more detail. Why is Destiny not the first complaint? What's going on here, essentially, to be as colloquial, to be able to maybe too colloquial about it. But it was incumbent on the judge to resolve those ambiguities, and I think case law supports that.
But the testimony wasn't ambiguous. There might have been a sidebar discussion, but it was clear from the testimony that there was that Destiny was not that first complaint witness. That it was Destiny's mom, and as my reading of the transcript, the victim made that clear on several occasions. So I'm just trying to understand what, from the evidence the judge is hearing, at what point would the judge be prompted to say, oh, it looks like there's a mistake underway here, I have to fix this? Because that didn't jump out at me. So
if you look at the Commonwealth v. Stuckek, which we rely on, in that case there was a note that the complainant gave to her guidance counselor. And the note indicated that she had previously told, I think, her mother or somebody else. They wanted to put the guidance counselor, I think they wanted to put the guidance counselor on as their first complaint. The mother and the complainant both said, we don't recall having any conversation about this, but the note set up that contradiction. So what I argue is that even though it was a clear denial on the complainant's part, that only sets up a contradiction that needs to be resolved as in Stuckek. And the case law there says a voir dire or some kind of determination as to who that first complaint was needs to be made. Even in King, the court says that determinations need to be made as to substitutions, or really any first complaint witness. So,
Isn't it possible that defense counsel made a tactical decision not to raise this issue because he used it to his advantage when he said, well, you didn't disclose to anybody until January, right? So why shouldn't this be raised through a motion for new trial?
I think counsel, just my read of the case, I think counsel was going with what he had at the time. I think as I argue in my brief, on Lisa's testimony, how do I explain this? challenging the cousin would have been not only consistent, but more consistent with counsel's strategy, in that the whole story was that this allegation came to light when the cousin made the allegation to deflect from herself. She had credibility issues. She was accused of stealing items from the house. She was, her mother was sufficiently overwhelmed with her that she sent her away to live with the complainant's mom. So that was an opportunity for counsel to impeach the cousin in a meaningful way, rather
Do
than
you
let
know
it-
that Destiny's version of a first complaint, if there was one, would be more helpful to your client?
Sorry?
How do you know that Destiny's version, if there was a first complaint, that would have been beneficial to you? How do you know that what she would have heard wouldn't have been more graphic and detailed than what was told to her mother?
Well, I think the point is that whatever that story was, she was open to way more impeachment than the mother, who is the picture of responsibility and adultness. But I think you take my meaning, Judge. But even that ambiguity gives us reason to remand this case.
Okay, but it's substantial risk of a miscarriage of justice, right? So we'd have to not only find an error, but find that it created a substantial risk of a miscarriage of justice. Now, if you had some evidence, although again, this probably would be better brought in a motion for a new trial, that what you claim your client said to Destiny was, hardly significant, was vague and whatever, helpful in some way compared to her mother's testimony, okay. But without that, how could we find a substantial risk of a miscarriage of justice?
As I argued in my brief, Your Honor, because Destiny this essentially allowed the Commonwealth to pick and choose the first complaint witness with the most credibility and the most complete version of the story. And I argue that the substantial risk of miscarriage of justice arises from that. That is prohibited. That's not allowed. They have to take the witness they have, not the witness that they want. And because there was,
But it's your burden.
that's, yes.
Okay.
I'll point to this one record fact, is that the judge said, during this exchange between the mom about the mother's testimony at sidebar, I'm concerned that the jury is going to think Destiny knew something or that she was told. In that moment, the judge should have stopped to explore what that was. And because nobody did what they were supposed to do in this case, the Commonwealth didn't justify substitution. We don't know what, I don't even think we need to know what the full extent of that complaint was, because case law tells us the definition of a first complaint is the report of a sexual assault. A great deal of detail is not necessary. So with that in mind, Destiny was ripe for impeachment, and in not calling her, it denied my client his ability to cross-examine that witness. I have a couple minutes left, Your Honor, so I'd like to touch briefly on the improper opinion testimony by the two state troopers. It is well settled, Your Honors, that a police officer may not opine on the guilt or innocence of a defendant. Anytime we see testimony that says, we were confident that he was the suspect, we knew it was him, and because that combination of, here's the recitation of the evidence that the police have, combined with their opinion as to what that evidence led to, that's improper testimony, and that's what happened in this case. Both Troopers Beccari and Troopers O'Connor stated, we believed it was Carlos, we knew it was Carlos, not much doubt it was Carlos, it wasn't a whodunit. All of that was improper testimony that should not have come in.
Of course, this all came in on cross,
It did, but it's
and it seemed to me, my reading of it, there seemed to be an evident strategy underway by defense counsel to highlight something for the jury, and that is that at no point did the police ever try to get a description of the perpetrator from the victim. And that's either because they were negligent or they did it intentionally so as not to provide some basis of cross-examination at trial. That seemed to be where he was going. So why would that be incorrect?
Because opinion testimony is not permitted either on cross, direct, or redirect.
I'm sorry, I couldn't hear you.
I'm sorry. Because opinion testimony is not admissible whether it is on cross, redirect, or direct. The Commonwealth, I think this, you make my sister's point is that she's arguing, the Commonwealth argues that it's okay because it came in, but it's not. In fact.
But mightn't it be a tactical decision not to object? I say to the officer, you didn't do any investigation, did you? And the officer says, before I can stop the officer, no, but that's because I knew it was Carlos. And now the defense counsel has to decide, I asked, do I now object and make it look like I only want half the story to go before the jury? I don't know. I have to decide. Why isn't that a tactical decision? And again, more, you'd get an affidavit of counsel in a motion for a new trial.
Well, I think we certainly have record evidence that it was not a tactical decision. When the judge said, counsel, this is the second witness where you're beginning to open the door to opinion testimony. Counsel said it was inadvertent. I think that's pretty clear evidence to counsel that this was not a tactical decision.
Your time has expired, but I think we have your arguments and your brief that fleshes them out even more. So thank you very much. Very helpful to us. We will hear next from Attorney Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. The victim's family is in attendance via the video link today. The Commonwealth argues that the first complaint witness, Lisa, was the appropriate person to testify as the first complaint witness in this case, and so that there was no error. However, if the Commonwealth is incorrect, to Justice Shin's point, I think there's no way that we could say this wasn't a tactical decision. The part of the defense theory was to say that the events were fabricated as a way to get the mother's attention away from this stealing of a watch. So it was a deflection technique. And I think to say that Lisa was the first complaint witness comported with that story that it was fabricated because of the family argument. So I think even if there was error, which I would first of all say that there was not, there would be no substantial risk of a miscarriage of justice here. And turning to the issue of the officer's testimony, I would say this was elicited entirely through cross-examination, and the defendant who purposefully elicited this testimony cannot now claim error after he chose to get this testimony on the record and after he used it to his advantage. I think just because it was unsuccessful does not make it error. And I would again say that even if this was error, it was not a substantial risk of a miscarriage of justice because I think it was clearly a tactical decision on the part of defense to elicit the information that he did. And because the Commonwealth would say there were no errors, there cannot be cumulative error in this case.
Let me just ask you about the, I'm curious, because when there's an allegation of a sexual assault, wouldn't you expect the first thing the police would ask of the victim, can you give us a description? I mean, unless, let's say, obviously, if you know who the person is, let's say it's a family member or something, you don't necessarily need a description. But if it's a stranger, wouldn't you expect the police to say, okay, can you give us a description, what did this person look like? General features, that sort of thing.
Sure. And I think the fact that the police didn't do that kind of played into the defense strategy here. I think because they didn't ask that question or those questions, that was something that the defense could kind of point to say that instead of conducting an investigation that was unbiased. The police here blindly took the word of the victim and then conducted an investigation that confirmed what the police already believed. So I think the fact that no questions were asked was favorable for the defense where that was their strategy.
How did they know where he lived?
I do believe it was the mother who spoke with the victim.
And then went around the neighborhood to
I think
try to
that
find a
the
car that
victim-
matched the description?
Yes, I think the victim had ridden his bike around the neighborhood, kind of saw the house with the RV and the car that he believed matched the picture that he'd received and the car that he'd seen. And then the mother and the victim did, I believe, get the name of the person that owned the home at that address. That's my understanding of how that was found out. If there are no further questions, I'll rest on my brief.
I see none. Thank you very much.
Thank you.
The case is submitted. The next matter we will hear is number 24-228, Commonwealth versus Fonseca. And we will hear first from Attorney Daniels.
Good morning, and may it please the court. Attorney Josh Daniels appearing for Mr. SIDNEY PIRES FONSECA. The Commonwealth and the motion judge below upheld this stop essentially based on three factors. This was a high crime area, the youths were trying to evade the police, and Mr. PIRES FONSECA's placement of his hands inside the front pouch pocket of his hoodie as filtered through Sergeant Simmons's training and experience. We suggest that each of these factors, though, deserves little or no weight in the reasonable suspicion calculus on this record, which is why the stop of my client can't be upheld. Beginning with high crime area and evasiveness, I think there shouldn't be much controversy that these factors should be heavily discounted under the SJC's more recent case law, particularly Evelyn, as well as the other cases I cite in my brief, Warren, Menaeus. Turning first to high crime area, the SJC, I think, has been clear, particularly in Evelyn, but even as far back as Gomes, that to rely on high crime area, there needs to be fairly specific evidence, pretty specific evidence, I think, of not only what crimes have occurred, but also where and when they have occurred. Preferably, as in Evelyn, the Commonwealth should offer dates, precise locations, and alleged perpetrators. On the other hand, vague testimony along the lines of there have been a lot of shootings downtown, as in Gomes, or there's been an ongoing feud between rival gangs, as in Evelyn, normally should not suffice to justify giving this factor weight. And here on this record, I think there's really only one incident that has the level of specificity that Evelyn demands, and that's the incident 9 days earlier testified to by Detective Almeida. That's at page 7 of volume 2 of the hearing transcript.
I don't read Evelyn to be establishing a rule about how specific the evidence needs to be. It was one sentence where the evidence in Evelyn was a police report that just listed other police reports involving alleged gang activity, and the court noted, well, there's no specificity about the dates. Here you have a lot more than that, right? You have multiple officers who testified in the weeks leading up to the shooting. There had been an uptick, or not shooting, sorry, leading up to the incident. There had been uptick in shootings between the two rival gangs in these two particular neighborhoods. So isn't that significantly more than what the court had in Evelyn?
I mean, I think I read Evelyn slightly differently, Justice Shin, in that in addition, it wasn't just the police reports as I read the court's decision. The court also references testimony by the gang unit officers that there have been an ongoing feud between rival gangs. I think that's the first sentence of the paragraph that I'm quoting from in my brief. I can get it if necessary.
Let's just assume for a moment that your construction of, well, even if your construction of this isn't right. All right, fine, let's knock out the high crime area.
Yep.
Why isn't there still, well, let me ask you a couple of questions. You're challenging only the stop, not the frisk later.
Correct.
I think I see why, given the evidence that developed during the chase. So the stop, and for the stop, there has to be reasonable suspicion based on articulable facts,
Yep.
as I read it, that a crime has been, is being, or is about to be committed. Do you agree with that?
Yes.
Okay. Leave out the neighborhood.
Okay.
Two kids come out from behind a house that's vacant. So they've been in the vacant, I guess, backyard of this house. The police are patrolling the area, and the kids, I guess they're probably older than kids. Or maybe, was one of them a juvenile, maybe?
Pardon?
Was one of them a juvenile? I don't remember.
Yes.
Okay,
One of
so
the-
two young people. When they see the police sort of following them in a cruiser, they run.
Yep.
It is in Boston, right, so Warren doesn't directly apply, but okay, let's apply it and say, well, merely running from the police is worth zero weight also. So we get rid of high crime and we get rid of that running from the police. Because maybe they're running because they're guilty of something, or maybe they're running because they don't want to interact with the police. But then they go immediately back to the backyard where I think one might reasonably think the police are going, right? The police want to know why they're running. They came out of a backyard. The police are going to go look at the backyard and see what they can find. But these two kids run back right into where the police are going to be. So maybe they weren't running because they were afraid of the police. They're going right back there. And even leaving that out, why are they going back to this vacant yard? And all we need is reasonable suspicion. Well, they're going back, it seems to me, for one of two reasons. Either they've left something there they're going to retrieve, or they've taken something from there that they're going to return. Right?
So I think the more natural interpretation of this is different than what you or the motion judge articulated. And I interpret the most natural reason for them returning to the yard as being just continuation of their efforts to evade the police. They're going there to hide. I don't
They're
think
going
it's,
to hide in the exact place the police are obviously going to go look at
I don't
next.
think it's that obvious that the police are going to go back there, at least not in the moment, perhaps with the benefit of.
All right, well, they don't actually hide, right? Because within moments, they walk out the front path.
Well, they
Right,
don't
they're-
know I mean, on my theory, they don't know the police are going to be right there.
Okay,
at
but
that
that's not my
moment.
point. They don't go and hide. They go there for a very brief period of time and then walk out the front path again, just as they had initially, right?
Right.
So now I'm a cop, and I'm looking around, and these people who were back here have come back again. Why would they come back again? And they didn't come back to hide, because here they are walking.
I mean, I still think the more natural explanation is they're trying to get away from, they're trying to evade the police and the backyard, I think, is the one place in this record where we know they are out of view of the police circling around the neighborhood, at least while they're in the backyard.
But they can't be reached in the whatever the
development. They can't be reached by cars in the development. The police can still get out of the car. They can see them in the development. So that doesn't offer any lasting sort of place to evade the police. I think they double back to the yard to continue to evade the police. I think the supposition that the judge draws that like they're going back there to retrieve a weapon is, if anything, far less logical because
It doesn't have to be a weapon. right? Any crime is good enough.
I mean, any
It could be
contraband.
contraband.
Right,
Could be
but-
drugs, whatever.
My point is, going back to retrieve contraband when you know the police are hot on your tail, I
Okay,
think,
so
like,
now they're moving out of the thing, and let's leave aside the hands in the hoodie pocket. That gets pretty messy pretty fast, right? Because everyone puts their hands in their hoodie pocket.
Yep.
And are we going to be looking at where the pressure points are? Maybe we are, but maybe we don't need that, because the other guy is clearly holding something in one of his pockets, right? Clearly.
I mean, I don't challenge reasonable suspicion as to the juvenile,
Okay,
correct?
so why isn't there reasonable suspicion that your client was aiding and abetting? And why isn't that good enough to not to frisk him, but to stop him for further inquiry?
I mean, aiding and abetting what? I guess
Whatever
is the
crime you've just conceded,
I mean,
the
the
other
only-
guy was committing.
I mean, the only crime that I think was the basis for reasonable suspicion here was unlawful possession of a firearm.
Okay,
And-
but we have to figure out whether there was reasonable suspicion.
Right.
And it could be anything. Now, frankly, 2 hands across the body seems a little more firearmy than heroin-y to me, but I've never, I'm not an actual cop.
I mean,
I don't-
my position ultimately is to stop my client, they need reasonable suspicion that he personally is committing a crime.
Why do we
And-
have to decide that? Because the two of them were together, right? So there's reasonable suspicion that the juvenile has something, right? So if there's reasonable suspicion to stop him, the officer gets out of the car and they both run off together. And we're saying, or everyone seems to agree, that the moment of the stop was when the officer starts chasing them, and they're still together. So how do you separate that out?
I mean, I separate it out because you still, I don't think there's enough on this record to infer, even on a reasonable suspicion basis, that there's joint possession of whatever is in the
No,
juvenile
I
pocket.
said aiding and abetting on purpose, because I agree that we don't know if there was joint possession or not.
Okay,
But they're doing something together.
right, but
Now, maybe he's just along for the ride, but it's reasonable to suspect that he's helping the other guy or that they're doing it together, right?
right, I mean, I guess I'm still stuck on how unlawful possession of a firearm can be an object of a joint venture in itself. Usually a joint venture has some other object like,
Aiding and abetting possession of a firearm, they go together and dig it up out of the ground or wherever. Obviously, I don't know where it was in the backyard.
I mean, that seems to be getting a little speculative about
Sure.
sort of what may be happening in the backyard and who can see what and who is
Isn't this
doing
just like Terry v. Ohio, where there's some concerted action that to a passerby might not look that unusual, but to a police officer with knowledge of what's been going on in the neighborhood and with training and so forth, might look upon this a little bit differently, where you have two people who appear to be engaged in a mission of some sort? Just like Terry v. Ohio, where you had two people walking up and down the street looking in store windows. Looks innocuous enough, but the police officer, based on his training and experience, knows something else is afoot.
I mean, in that case, my recollection is that after walking back and forth in front, they would confer a little bit.
I mean, as to training and experience, I don't think Sergeant Simmons is really counts for much under footnote 8 of MATA for reasons that I've explained in my brief as goes to sort of the hands in the pocket.
Well, certainly, yeah, with respect to the hoodie, it's very ambiguous at best.
Right. My position at the end of the day is I don't think there is enough specifically on this record as to my client to support a reasonable suspicion
How does
that.
the officer chase after the guy, let's say he only suspects the juvenile?
Yep.
How does he chase after him and not your client if they're running off together? That's what I'm not understanding.
You shout, "You and the down jacket, stop." You specify who you're going to stop using words, I
Did he do
suppose.
that?
We don't know on this record.
I mean, it's all happening very quickly.
It is.
He chases after him. At some point, they split up, right?
Yep.
And at that point, your client runs back, as I understand it, towards the officers, and now he's running in a highly unnatural manner, and there's pretty specific testimony. They thought at that point he was holding a firearm. at that point, surely there's reasonable suspicion to stop him separately from the juvenile, but before that, they're running off together. So it's curious to me why, if there's reasonable suspicion to suspect the juvenile of carrying a firearm, that the chasing after your client was improper in some way.
I mean, that's sort of a function, I see it as a function of the moment of seizure. So those are post-seizure observations that shouldn't factor into reasonable suspicion as to my client.
So he should have said, as he was running after them, you in this coat stop, you in the sweatshirt, you can keep going. I mean,
that is my position.
okay.
And my position is there isn't enough here individually to suspect my client of personally having a firearm. And I disagree with the motion judge, as I discuss I forget if it's footnote 7 or footnote 8 of my opening brief, that I don't agree with the judge's move that you can just sort of conflate the two of them together, and so it doesn't matter who actually has the gun on them. I think in order to stop my client, you actually do need reasonable suspicion that he personally is in possession of a firearm, because there's no other basis for believing that he's committing any other crime on this record. I see that I have 40 seconds left, and if there are no other questions, I just ask that you reverse the motion, Judge.
All set.
Thank you very much. Excellent argument.
Thank you.
And we will hear next from Attorney Kidd.
Yes, good morning, Your Honors. If it pleases Your Honors, my name is Rob Kidd. I represent the DA's office, the Bristol County DA's office. I'd like to point out for the court may already know, but an old colleague of mine, Miss Brenna Farrick, an attorney, is here with her eighth grade class. She's a teacher, and she's here observing, so she's happy to be here.
Always happy to have guests.
Thank you. So anyway, getting right to it, Your Honors, starting with some of the factors that calculate into probable cause. Let's start with the nature of the neighborhood, shall we say. Here we have a case where, yes, there has been, as Judge Shin pointed out, there has been live witness testimony from police officers that there has been an uptick in this particular area of the city in the South End, an uptick in gang violence, that they are feuding with the West End gang in that area. And that particular South End area was the subject of a shooting 9 days prior of a named individual named Rafi Jimenez. Rafi was shot by someone who asked him if he was, quote unquote, I think he asked the gang name, and then when there was no response, this person shot Rafi in the chest, and he was transported to the hospital. And then the testimony was that several days after that, there was a rival shooting on the other side of town, in the West End. So you have these two incidents occurring within a short period of time.
Let me put it all, let's say we accept that. Okay, high crime neighborhood, running from the police. The linchpin, I think, of suspecting the defendant of possessing a firearm is seeing him doing something that looks like he's possessing a firearm, according to the officer. That is, if he had walked out same as he had before, there wouldn't be reasonable suspicion, probably. I don't know what your position is on that, but I want to talk about what it is, what's the crime supposed to be, and how we see reasonable suspicion of that.
Okay. Well, yes. So what is the crime? So first of all, the judge specifically found that the crime was unlawful possession of a firearm, and she found that the youthful appearance of these individuals gave the police officer reasonable suspicion to believe that neither one of them could have an...
Sure, I think you point out in your brief also, lawful possessors of firearms don't store them behind empty houses.
Correct.
So it's probably an illegal firearm if it's a firearm.
Yes, that's the other thing. So if you buy or if you believe that reasonable suspicion formed after the two young men exit the yard, and with one of them in that unusual position...
All right, so let's do that. Let's look at that. All right, one of them is in that unusual position, and I don't want to heap a huge amount of weight on concession, but it looks a lot like someone with a firearm, a lot. The other guy has his hands in his hoodie pockets, and I understand completely what the officer was saying about maybe you can see that he's holding something toward his waist. Is there pressure on the outside of the thing? But that's a pretty tricky one because the number of people walking around with hands in their front pockets is probably quite high. And even one's holding something, their phone or something in there, is probably quite high. And so why do we suspect it's a firearm? I don't know. Just because the other guy has one doesn't make it more likely, might make it less likely. Why, oh, there are two firearms, you know what I mean? So if we leave out the hoodie, but we still have the juvenile apparently possessing a firearm, can the officer stop the defendant? You don't use, I said aiding and abetting, but I'm making that up, right?
Yes.
You don't say aiding and abetting, you say joint possession.
Yes. And the answer is yes, he can stop both of them. And Sweeting-Bailey tells us specifically that part of the probable cause calculation is the companion of the defendant. We can look at that, and we have to look at that. Why did these two young, stepping back, why did these two young men stay in that housing development? Why are they both talking frantically, quote unquote? That's not running from the police. They're on their cell phone
Wait.
talking.
My recollection of Sweeting-Bailey is that the defendant there goes a little crazy near the back of the cruiser when they're trying to cuff him, and the theory is he's trying to draw attention away from the other people he's with in the car.
That's correct.
But there's nothing like that here. They're just two people walking together.
Right, but and also the facts in Bailey is that other members that were in the car, and that happens to be from our office, Sweeting-Bailey, but other persons that were in the car were known, quote unquote, gang members. And it's in that context that I believe the court specifically says that can be a calculation, the persons that he's with. I suggest that police, in this particular case, they absolutely had reasonable suspicion to stop both of them. If they're both in the yard, what are they both doing in the yard?
I mean, there was no evidence that they thought they were gang affiliated.
No, not in this case, no. But I'm just saying that Sweeting-Bailey stands for this proposition that we can consider.
Okay, so he brings his friend with him. Let's say we don't know that the defendant has a gun, but we have reasonable suspicion that the juvenile does. And they've been doing all this stuff together. But joint possession requires the friend, in this case the defendant, to have, I don't remember what the exact phrases are, but like the power, the ability to actually control the weapon, and I don't remember what the other piece is. But if they're going to get the juvenile's gun, it's not the defendant's gun.
Yeah, well, I would step back from that and say that I don't think our theory doesn't have to be joint possession of the juvenile's gun. Mm-hmm. I would suggest that based on all of the totality of the circumstances, if you have both of these individuals running from the police, both of them engaging in furtive movements, talking frantically on the cell phone, both of them returning to the yard, both of them coming out in different positions than they were, one of them with a very significant position, suggesting a firearm, the other one, now he's got his hands up against his body. I suggest totality of those circumstances for the police suggested that they had firearms. Now, it's interesting to note that Detective Gwodz, I don't know how to say his name, but it's Gwodz, remember the defendant was caught in kind of like a baseball pickle, and he's running back and forth, and Gwodz, as soon as he saw the defendant, drew his weapon. That's telling to me that an trained, experienced officer...
Wait, that's during the chase?
Yes.
Well, during the chase, other things happen, like he starts running with one hand against his waist.
Yes,
I'm asking at the time of the
yes.
stop, I mean, and they're not...
Yes.
Presumably because of that, the defendant isn't challenging the pat frisk.
Yes.
But I'm still stuck on is the reasonable suspicion the defendant has committed a crime? And the reason you don't think it's aiding and abetting?
I think it could be aiding, if you're saying that by aiding and abetting, if you're trying to say that they're both guilty of the juvenile's gun, is that what the question is?
The juvenile would be guilty, would be reasonably suspected of possessing a firearm. But if we don't use the hoodie, if we don't think that's a clear enough thing to give reasonable suspicion, so we don't think there's reasonable suspicion that he was possessing a separate firearm, has he,
Oh, I'm sorry. I didn't-
no, go ahead.
I think there is reasonable suspicion that the defendant was possessing.
No, I understand that's your argument. Although you also mentioned joint possession in the brief. All right.
How do we look at this analytically when there's a seizure because two people have run and they're being chased, and let's say only one of whom is suspected of a crime and the other one isn't? How do we address that analytically?
Well, I don't agree with the premise. I think they're
I
both.
understand, but let's just assume that the officer only had reasonable suspicion as to the juvenile, but they run off together. What then?
I mean, I think that for other reasons, for safety reasons, I think the officer would have been justified in asking both to stop doing a pat frisk. They're both in that yard. One of them certainly is, glaringly looking like he's holding a gun. The other one has now changed his hands positions. I mean, I understand what Justice Rubin is saying, but it's a little unusual. I mean, the normal way that people have their hands in their pockets, is sort of like down, and now he's got his hands up against his chest like he's holding something. It's unusual when you look at it in the context of his companion, and it suggests to me enough reasonable suspicion for the police to stop both of them. And the court may disagree with that, but.
And wasn't that what the motion judge seemed most moved by, that it was the change in position that was so significant?
I would say that's probably fair. She put a lot of emphasis on that. But again, she looked at it in the entirety of the circumstances, and the uptick in violence, and all of the furtive movements, and trying to avoid police. And by the way, Evelyn, which is the case that the defendant cites as being sort of critical of this whole high crime thing or flight from the police thing, in Evelyn, the only thing you have is the defendant running from the police. That's the only thing, and he's moving his eyes. His eyes are, avoiding eye contact. And as I said in my brief, the conduct here is much more dramatic than the conduct in Evelyn in most of the cases. I mean, these guys are, like I said, both of them are running to a housing development. They're both peering from behind buildings. They're both talking frantically on their cell phones. That's what the officer testified to. And now they both disappear, and they both end up at the same place where the police first saw them. That is highly suspicious behavior, and I suggest that combined with the unusual position of both of their hands provided a sufficient probable cause for the stop, and I would urge the court to uphold the motion judge on that basis.
Not to belabor the point, but I'm actually perplexed by this. So let's say you have two people, one who the police have observed directly committing a crime, okay? The other one, they haven't observed anything. They get out of the cruiser, they both run off together. All right, so now they've seen one of the men actually commit a crime. At some point while they're running off, they separate, and then the one who has not committed a crime does something in the course of the chase that then gives rise to reasonable suspicion. What is the point of the seizure as to that person?
In that scenario, which is not this scenario, once the police see that other individual do something that they believe provides reasonable suspicion, that's when well, yes, that's when they can pursue him.
The one has not committed a crime, he's not been observed doing anything.
Correct.
And he runs off with the other guy, and the officer chases both of them because they're running together. Is that the point of the seizure as to the second person? So then even if he does something during the course of the chase that does give rise to reasonable suspicion, doesn't matter because he's already been seized?
It's an interesting question. I'm not going to say that I have the answer to that. I don't know when would I know what the question is. When would the stop begin? Does it begin as soon as they start running, or does it only begin when they form suspicion?
Well, in the absence of some reason to think that the police weren't interested in or getting out to talk to or something the second person. I mean, and of course, to be here, eventually the person has to have been arrested for a crime. It seems to me in the absence of that, how are they to know any better than we do that they're being chased by the police? And so wouldn't they be seized then? I mean, it can't be that the hidden subjective interest of the police in only one of the two, unless there's some evidence of a way that was indicated to anybody, would alter the fact that they're both seized when you start chasing them. But this isn't even before us, right? You guys have agreed on when the stop occurred.
I think the agreement is that as soon as Detective Almeida, who was in with Woods' cruiser, got out and started running after both, that's when the stop, I think we agreed that that's when the stop begins.
And his testimony at the suppression hearing was that he suspected each of them of possessing a gun.
Yeah, yes. And I agree with that.
Yes, of course.
Yes, I have 30 seconds left to run the clock down here. So if there are no other questions,
Okay, I see no further, just checking, I see no further questions. Thank you very much.
Thank you, Your Honor.
Excellent arguments from both of you. Thank you. The case is submitted. Our next case, also I remind counsel partially impounded, so I trust you will follow whatever the impoundment order requires us not to talk about, is number 23776. This is Commonwealth versus Beltran, and we will hear first from Attorney Opperman.
Good morning, and may it please the Court. Erin Opperman on behalf of Mr. Beltran. We are here on an appeal of the denial of Mr. Beltran's motion for a new trial, wherein he raised three issues, two issues pertaining to a conflict of interest held by his trial counsel at the time of trial, and one allegation of a Brady violation. I want to start with the conflict of interest relating to the Commonwealth's accusation on the eve of trial that the defendant's lawyer, along with him, conspired to bail out the complaining witness in this case and ensure her absence from trial. And I want to remind the Court the definitions recently cited approvingly by the SJC in Commonwealth versus Brown, the definitions of what an actual conflict is. And the first is found in Commonwealth versus Perkins, which reminds the Court that the critical inquiry is whether the lawyer has a competing interest or responsibility that will materially interfere with the lawyer's independent professional judgment in considering alternatives or foreclose courses of action that reasonably should be pursued. The second is found in Commonwealth versus Mosher, which instructs that an actual conflict exists where prejudice is inherent in the situation, such that no impartial observer could possibly conclude the lawyer has undivided loyalty. The existence of the actual conflict in this case is evidenced by trial counsel's first and immediate response to being accused by the Commonwealth of being involved in the bailing of their complaining witness.
Judge Kenton Walker, didn't she put all of this to rest when she looked at a transcript of the jail calls that the prosecutor was relying on? And by the way, the prosecutor said it was by implication that counsel was involved somehow in this. The judge then took a break, reviewed the transcript, and then came back on the record and said that she didn't read the transcript the same way as the prosecutor, and that in fact there was no indication that the lawyers were in any way involved in this witness not showing up. So shouldn't that have been the end of it right there?
Well, I'm not entirely sure what Your Honor means, the end of it, whether there's a conflict.
Well, as far as a conflict.
With respect to whether that was the end of the existence of a conflict, the answer is no. Judge Kenton Walker's opinion about whether a single transcript referenced by the Commonwealth indicated in her opinion whether trial counsel was involved doesn't completely answer the question of whether trial counsel was conflicted from pursuing certain avenues of relief for his client or advising his client on certain avenues of defense at trial.
But I'm trying to put myself in the position of this lawyer who, on the eve of trial, there's this accusation made by the prosecutor. The judge looks into the accusation and says there's nothing to it. So if I'm that lawyer, it seems to me at that point, I'm thinking, okay, there's nothing to it, I'm all set, let's get on with defending my client and let's move forward.
So, again, whether that settles the issue of whether a conflict existed, the appellant's position is obviously that it did not.
Wait, I thought that the prosecutor said in open court that he was investigating the lawyer.
He did.
Am I wrong about
so
that?
The prosecutor said, when asked directly, I believe that trial counsel knew that the complaining witness would be bailed and not appear for court. Obviously, Judge Kenton Walker reviewed, the record isn't even clear exactly how much of the transcript she reviewed, how many lines. The transcript is obviously part of the record appendix, and I'm sure this panel has reviewed it itself.
But it doesn't matter. All right, so some judge not sitting on the case says, oh, I don't think he did anything. But doesn't he still have to worry about the prosecutor?
Well, of course he does.
He was eventually indicted, in fact, and tried on this charge, right?
Indicted and tried,
Yeah.
yes. And he made it clear that he was affected by the accusation. The quote was, I am offended. At the motion for a new trial, he testified again that he was offended, that he was angry. He indicated to the court that he felt the prosecutor was attacking his reputation, his credibility, and in the very next breath, immediately divulged attorney-client confidential information when he said, I didn't tell my client to do anything. In fact, I told him the opposite. I told him don't have anything to do with this client.
Let me ask you this, because this is something that happens with some frequency in the trial court. You're in the middle of a trial, you're the defense lawyer, you've been working hard for your client. Suddenly, the defense counsel asks for a sidebar with the judge. The prosecutor and defense counsel go up and talk to the judge. Defense counsel announces, Judge, my client's very unhappy with me. He wants to discharge me from the case. Okay. He's accused me of this and that, and whatever. So the judge says, okay, you know what, we're going to take a little break. Why don't you have a few moments, you can go out and go into the lockup, you can talk with your client. So the jury's discharged for a little break, they get their coffee. During the break, the discussion happens. Counsel comes back and reports, all is fine. We're ready to move forward. Now, by your theory, just the fact that an accusation has been made, and in this case an accusation by the client himself, that counsel has done something improper, is very unhappy, wants to discharge him in the middle of the trial, that right there, that's an actual conflict and counsel can't be involved in the case. And yet, it happens with great frequency that whatever issue there is resolved, the case moves forward, the trial goes on, and it's not an actual conflict. So regardless of what happened years later or months later in this particular case, as far as the defense lawyer being charged and ultimately acquitted, I'm asking at this moment in time, at this moment in time, how is there an actual conflict of interest that would require this lawyer who's prepared for this trial, who's been working with his client, that he has to suddenly step away from the case? Or put another way, what if the prosecutor said, Judge, I think this lawyer can't represent this defendant. He should get off the case now.
He should have said that. And I wish he would have said that.
On the basis of something that the judge had said there's nothing to it?
The fact was, on June 19th, when this accusation was lodged, the Commonwealth was actively investigating trial counsel for witness intimidation. 2 days later, on June 21st, 4 days before trial, the Commonwealth presented a witness in the grand jury to begin to obtain evidence against trial counsel and simultaneously sought to introduce consciousness of guilt evidence against the defendant, all the while insulating its belief that trial counsel was involved from the jury.
Did trial counsel know about the investigation? Because doesn't that matter? It seems to me his loyalties could only be divided if the allegation was either true or he's being investigated about the allegations and he knows that. I don't see in this record evidence that he knew he was being investigated.
I think the record is clear that what the Commonwealth indicated was they believed trial counsel was involved and they were investigating the matter. They disclosed that they had or were imminently, they disclosed that they were...
At the hearing before Judge Kenton Walker?
They disclosed at the hearing before Judge Kenton Walker that they were investigating the matter. They disclosed that a month earlier when the complaining witness didn't show up for trial. On May 27th and 28th, they appeared in court, on May 29th and May 30th, they appeared in court. BH did not appear. The Commonwealth indicated that they were investigating and that they believed something serious was going on behind the scenes.
But that's not investigation of counsel, right?
I think it's clear when the Commonwealth indicates that they believe counsel's involved and they are investigating the matter, that includes...
But the grand jury is a secret proceeding. Was there any evidence that a target letter was sent by the prosecutor's office to defense counsel during the trial or before the trial?
No, there wasn't, as far as I know.
So he wouldn't know that he's a target of an investigation?
It is a mistake for this panel to conclude, first, that on this record, that counsel didn't know he was, or believed he was not being investigated.
I'm sorry, could you say that again?
I said it would be a mistake to conclude that defense counsel or trial counsel did not believe or believed he was not being investigated. There's nothing in this record.
The prosecutor even says we're doing an investigation and says, I personally believe that he is involved in this. Now, that's the prosecutor saying it. How can let's assume, although I don't know why we're doing this, but let's assume that he didn't, in fact, suggest this course of action. Of course, he may have, but let's assume he didn't. Is he going to call to the stand witnesses, BH, or is that, I don't remember her initials, call her to the stand and say, what do you know about this release? They're saying that it proves consciousness of guilt, when there's some risk that she's going to say, oh, no. He said this was fine with the lawyers. He said, in fact, that you suggested it. I mean, would you put that person on the stand when the prosecutor's sitting right there saying they think you're involved and they're investigating it?
I agree, and you wouldn't, because you would be conflicted from doing so. There is quite a bit of language about issues very analogous to this one in the federal case law that I cited, and I think it's U.S. v. Fulton that says, if a lawyer is accused of being involved in a crime similar to the one at bar, a conflict necessarily exists for one of two reasons. One, either it's true, and Fulton goes on to instruct courts that in a situation like this, they should assume the allegation is true. And they should assume the allegation is true because the government in federal court, here the Commonwealth, believes strongly enough in what its witness is saying that it is lodging indictments and presenting witnesses to testify as much in court, which is what happened here. The Commonwealth believed enough in what its witnesses were saying about trial counsel's involvement that they presented they presented the evidence to a grand jury, they indicted trial counsel, and they tried him. And his case, his trial counsel filed a motion to dismiss under Odell, and that was denied. Judge Locke found that there was probable
Fulton's
cause.
a little bit different because it was a government witness who was leveling the allegation, right? And so the court said counsel could not question the witness about the accusation when they're put on the stand. Are there any Massachusetts cases involving this factual scenario that you were able to find?
I would say that Commonwealth versus Brown is pretty close. And
It's not about that's an ineffective assistance.
I would say it's pretty close in the sense that what it addresses is whether an actual conflict exists when trial counsel is faced with strategic decisions that call into question his own actions, his own advice to his client, and that counsel in that situation can't even give detached advice about whether or not the defendant should waive that conflict.
Okay, so I've read the federal cases, and at least some of them seem to suggest that the allegation has to have some foundation in order for an actual conflict to arise. Somewhere in your brief, you said the truth of the allegation doesn't matter at all. So in your view, a prosecutor could level a completely baseless accusation against defense counsel, and there would be an actual conflict?
I would say that the truth to this accusation doesn't matter. I agree that there needs to be some foundation, and I believe that's what the SJC has said. But I also believe that in light of the particular facts of this situation, the fact that the Commonwealth accused trial counsel of being involved in bailing out a complaining witness, the alleged victim in a human trafficking case, simultaneously begun to investigate trial counsel, called a witness into the grand jury to testify against counsel prior to the trial in this case, indicted him and tried him, is enough of a foundation for this court to find that an actual conflict existed.
Let me just ask you about the truth, okay? Because you're saying that the truth of it doesn't matter, but it seems to me, first of all, it's the defendant's burden at this point. It can't be based on speculation to demonstrate that there's an actual conflict. The motion judge, who was also the trial judge, is not just a potted plant. He wrote a 24-page opinion, which I thought was very well written, very detailed, addressed all of the arguments, and in it, notably, he credited the testimony of the defense lawyer. And that seems pretty important because part of what the defense lawyer said is when he was asked if you were involved in the bailing out of this witness, and he said, "Of course I didn't. I had nothing to do with it." So doesn't that
What is he going to say? At that point, he's been tried, he's been acquitted. Under no circumstances would a trial counsel in his position testify at a motion for a new trial. Well, double jeopardy.
Are you saying that the
has
judges?
attached. In fact, I did advise my client.
Are you
to
saying
bail
the
her.
judge's finding of fact is not relevant to us at all?
I am saying that, one, I don't believe that the motion judge found that that trial counsel wasn't involved. I don't believe that he made that
Found him
factual
credible.
finding.
Found him credible.
Again, and I don't think that that is the equivalent of concluding that trial counsel wasn't involved. I think he found that trial counsel denied being involved, but I also think that in this particular situation, when a trial counsel is accused of securing the absence of a complaining witness from trial, trial counsel's denial of being involved is irrelevant.
I mean, I have to say, I guess I have to think more about what the truth has to do with it. This is a case where trial counsel is running for the head of the office that's accusing him. His first reaction to this is politically motivated. But there's some evidence there that that is the basis of the allegation. This is a highly unusual circumstance. The defendant, through a third party, bails out. I mean, I don't know how unusual, but it seems highly unusual to me. I've never seen something like this before. The idea that he is supposed to not be afraid he might be wrongfully prosecuted just seems, I don't understand why we're making that assumption. The question is, can he represent this guy? And I think the answer in this case, maybe there's a case of a baseless allegation where it wouldn't do it, but I don't see how this lawyer is in a position to really dig deep into what all witnesses say about the consciousness of guilt aspect of that evidence. I mean, whether he's later acquitted or I mean, I'd have to look at the exact verbiage.
Well, for us to conclude that there is enough foundation for this allegation, I think you said there has to be some foundation. Do we have to be able to say on this record that counsel knew he was being investigated?
I don't.
So then what's
I do think he knew, but I don't think this panel needs to conclude it.
What's the divided loyalty? Either it's because he knows he might be investigated, or there's enough truth to the allegation that he would be fearful that he's going to be investigated. So which do we need to find?
So I think you could find either. And I think that there is enough of a foundation here. Ms. Cruz testified to a grand jury that she overheard a conversation between trial counsel.
I know the facts. I'm asking, as a legal matter, do we need to be able to say he knew he was being investigated?
No. The only question that the panel needs to answer are, were there avenues of defense that counsel was, due to the nature of the conflict, inherently conflicted from pursuing? And there were numerous available avenues of relief in both arguing against the admission of this evidence or defending against it at trial that trial counsel was precluded from engaging in. And to me, the easiest one is, it is a constitutional duty of trial counsel to advise and explore avenues of resolution of a case before trial, including cooperation. The Commonwealth sought the defendant's cooperation within, I think, a month after this trial. That sheds light on the fact that they were likely willing to at least entertain cooperation from the defendant that included global resolution of his cases.
Am I right? I'm looking at your brief now, and your time has expired, so we'll give you additional time if you need it. The court says to the prosecutor, the question is whether or not, based on what was said on these jailhouse calls, that one could draw the inference that the lawyers knew she was going to be bailed out and therefore wouldn't appear. And the prosecutor says, that's what I'm suggesting. So he says he has some evidence. I mean, I don't know how much evidence you need to have. Obviously, he hasn't been convicted of the crime. It's an accusation.
I want to return, and I know I'm over. I just want to return to what Justice Hodgens pointed out with respect to the frequency with which defendants ask for a new lawyer and raise to the court that some sort of conflict exists. Though that, in a general sense, is very common, I would say the prosecution of trial counsel for something like this is incredibly rare. And this is truly a unique situation where, luckily, this panel has the benefit of hindsight. And in hindsight, a conflict existed between trial counsel and the defendant There were avenues of potential defense that I know I would have explored if I was his counsel at the time. If I have a client who I think has information the government wants and might get something in return, I'm certainly going to communicate with the Commonwealth about whether or not my client...
Okay, we have that argument in your brief, but I do want, and you were well past time, though it's our fault. I just want to make sure, are there any other? Okay. Your time has expired. Thank you very much. It's certainly an interesting case. We will hear next from Attorney Sweeney.
Good morning. May it please the Court. Elizabeth Sweeney, Special Assistant District Attorney for the Commonwealth. The motion judge, also serving as the trial judge, did not abuse his discretion in denying the motion for new trial after an evidentiary hearing where counsel testified. The defendant cannot establish that there's an actual, let alone potential conflict, nor can he establish ineffective assistance of counsel on this record. I'd like to direct the Court's attention to the standards of actual conflict and potential conflict, where those are the guideposts in this issue today. And citing to Mosher, where independent professional judgment is so impaired, either by his own interests or by client interests, that no impartial observer could conclude that there's divided loyalty. And the Court in Mosher also cites to the rules of professional responsibility and instructs this Court to refer to them when addressing issues of conflict. And in Rule of Professional Responsibility 1.7, as I cite in my brief, in the reporter's notes to that, the courts, they state that the mere possibility of a conflict is not enough to establish actual conflict. And as far as the potential conflict, the defendant cannot establish that as well under Fogarty, where the defendant needs to show actual prejudice under the very familiar...
Let's stick with actual conflict, if we could, for a moment.
Sure.
Why isn't there an actual conflict here? The prosecutor comes in and says, I believe, in part based on jailhouse phone calls I've listened to that maybe no one else has, I believe that this counsel has committed a terrible crime in cooperation with this defendant. I want to use that crime in demonstrating consciousness of guilt of this defendant, but everyone should know this lawyer was part of it.
So first, in referring to the record, I'd instruct this Court to review June 16th, 2018 transcript, pages 18 to 19, where in front of Justice Kenton Walker, the attorney is explaining the situation here. The Court says, okay, so the question is whether or not was based on what was said in these jailhouse calls, one could draw the inference that the lawyers knew she was going to be bailed out and therefore wouldn't appear. The attorney says that's what I'm suggesting. Attorney Rubin says that he's offended, it's politically motivated. The Court reviews the jailhouse calls and then comes back and says, I've read this, and what, are you suggesting based on this that the lawyers were aware that she had been bailed out? And he says, I'm suggesting that there was a plan put in place. And at that point, if you review this transcript along with the jailhouse calls, that does not rise to the level of an actual conflict where, one, it is an ongoing investigation, two, there's no accusation at that point that this attorney actually did anything. It was a...
If I said that to you and I'm a prosecutor, wouldn't you get a lawyer before speaking to me any further?
The Court reviewed the jailhouse calls and
it doesn't matter. It's not up to the Court. Who he's scared of, who a defendant or potential defendant is always scared of, is the prosecutor, right? Some judge in a different case saying, I don't find anything here, let's keep going. It didn't keep the DA from indicting him or however he was charged, right?
On a separate record from what the Court had at that point, which was the jailhouse calls, and in addition, we have to review prejudice, and here this attorney requested all the discovery, which if he was allegedly involved, would he have requested all the police reports, any statements by the witness, and then...
What day did he request those?
He requested those shortly after the Commonwealth explained that it was going to be introducing the consciousness of guilt.
And was he given the grand jury minutes, which occurred before the trial started?
He was not given the grand jury minutes, nor was he entitled to those at that point, where it's an ongoing investigation. He was given the statements that BH made to police, he was given the jailhouse calls, and he had the information that the Commonwealth had, and then he argued strongly against introducing this evidence at trial. There's no actual conflict of interest if you review...
Why isn't the threat of an investigation enough to give rise to a conflict?
There is no threat of investigation of the counsel at this point.
The prosecutor has said he or she believes that this attorney is involved in the bailing out.
So the court says is the question that one could draw the inference that the lawyers knew that she was.
I don't really, not that I don't care what the court said, but the question really is, if the attorney is aware that the government suspects him of wrongdoing about the circumstances of this bailing out, doesn't that give rise to divided loyalty? So let me put it in a different way. The crux of the claim against the attorney seems to be Cruz's observation of this conversation that occurred between them privately.
Yes.
Where the attorney is alleged to have said, it'd be better if she were out. Implication being, it'd be better if she were out, because then she would go missing and would not be available to testify. So she's given sworn testimony about this. So if that's true, even if it doesn't rise to the level of witness intimidation, wouldn't a different attorney have been able to potentially use that to argue against consciousness of guilt?
As the judge found in reviewing the entire record, and he was very familiar with it as he was the trial judge, no, because that would involve an admission by defendant that defendant was involved in this.
Right.
It's not a mitigating factor, and
That goes to whether there's prejudice, but before we get to prejudice, we have to decide whether there's an actual conflict, because the SJC has said in that instance, prejudice doesn't matter, right? So the question is, did this attorney have some incentive not to pursue that avenue of defense because of his own interests?
No, and again, there is no, on this record, avenue of defense that he did not pursue. As the motion judge found in the record, the defendant doesn't say what he would have done differently.
The avenue of defense is him bailing out this witness was not indicative of feelings of guilt because he understood the attorney's private statement to him, it'd be better if she were out, to essentially be blessing him to bail her out. That's the avenue of defense.
And then the jury in the court would have heard that he had bailed her out, had someone pick her up, bring her to a car, drive her to Brockton, gave her cocaine, heroin, crack cocaine, and all that information was here. However, it's not, as the motion judge found, a mitigating factor. And it's not the actual charges that the defendant's on trial for, and I think that's an important distinction as well. The cases cited by the defendant and the Commonwealth and the judge in his decision talk about how there's a conflict of interest and divided loyalty when the attorney is jointly culpable for the crimes that are on for trial, and that's Commonwealth v. Schreier. Here, as the judge found in his decision, that the consciousness of guilt evidence was not what he was on trial for. It was introduced. There was a mitigating instruction provided. So I agree with the motion judge that it's a somewhat collateral issue, and at that point, there's no evidence that the defendant could have introduced as a mitigating factor involving the attorney.
Are there any Massachusetts cases arising in this factual scenario that you're aware of?
This factual scenario, no. I did review numerous conflict cases. There's Schreier, there's Crokin, there's Agbanyo, which is somewhat different, dealing with counsel vying for an assistant DA job, and then there's Brown, which is more of an ineffective assistance of counsel analysis than the conflict issue that we're faced with here today. But if we're addressing the issue of the divided loyalties, I'd point the court to Schreier, which I think is the most somewhat on-point case out of all of them. The federal cases, I don't think that they're necessarily applicable to this analysis, where they don't get into the divided loyalties for somebody who's not charged with a crime. All the cases cited by the defendant, as the court points out in its motion decision, are when counsel is charged with or seriously involved with similar.
Well, there are federal cases that arise in the obstruction of justice context, which seems to be pretty similar.
There's no evidence of obstruction of justice on the record here.
There's an accusation.
There's an accusation of intimidation of a witness by defense counsel. However, on this date, and the date that we're referring to in the transcript, we have the jail calls, and we have the Commonwealth saying that we're still investigating
Let me
this.
ask you this. Let's say at that point in time, the Commonwealth said, I move to disqualify counsel based on conflict of interest. We're opening grand jury investigation. He's part of the investigation. Would it have been proper to allow that motion?
That would be in a different circumstance. However, I don't think at this point on the record, the Commonwealth could have moved to say that based on the somewhat vague jail calls. The judge found that they were meritless.
They had opened a grand jury investigation. Let's say at that point in time, before Judge Kenton Walker, the prosecutor said, I move to disqualify this attorney because we have opened a grand jury investigation into the circumstances, the bailing out, and there is an actual conflict. He's potential subject of the investigation. Would it have been proper to allow that motion?
If the judge found that there was an actual...
If the prosecutor moved to disqualify based on the opening of a grand jury investigation into counsel?
Yes, however, at this point, it's not clear if the grand jury was directed towards counsel or the entire circumstances of how this was unfolding. And I think that that, again, is an important distinction. We have the jail calls, we have the statement where she whispered, the attorney suggested it. We have the statements by BH who said she did not receive any direction from the defendant's counsel, any attorney, in her bailing out, and she didn't know who the person was that picked her up.
I'm not understanding. So you agree it would have been proper to allow a motion to disqualify counsel? Had the motion been made at the time based on the opening of a grand jury investigation, you agree it would be proper to allow that motion?
No, I'm not agreeing to that. What I'm saying is, in your hypothetical, if the Commonwealth went in there and said, I am investigating this specific attorney because we have evidence that he was involved in this, but the record, if we turn back to the jail calls, which the judge reviewed, we do not have evidence that this attorney at this point had enough to disqualify himself.
And Judge Kenton Walker actually used that word that you just used, meritless, right?
Exactly.
She said the prosecutor's accusation was meritless.
She found that it was meritless. The defense counsel heard her say it was meritless. Therefore, he carried on with his defending his client, requesting the grand jury, and everybody was aware as to the content of the jail calls. The Commonwealth continued to investigate. There was grand juries held in June and I believe in September of that year after the trial had concluded. And so I don't think viewing this in a vacuum is not how we should review divided lawyers.
I assume your position is that the lawyer is in fact guilty of witness intimidation.
That is not my position.
It's not your position? You prosecuted him. The DA's office no longer thinks he's guilty? They think they wasted everyone's...
The attorney was found not guilty after trial.
I understand he was found not guilty. I assume you think that was wrong.
As the Commonwealth, I'm not going to weigh into...
The DA's office, when people are acquitted, thinks they made a mistake every time. They shouldn't have prosecuted them.
I'm a special assistant attorney assigned to this matter.
Why were you
appointed?
Do you know why you were appointed?
Because Worcester District Attorney's Office has a conflict on this case.
A conflict, and the conflict is that it thinks that he's guilty of the crime, and you have to argue there wasn't enough here to show he's guilty of the crime.
When I was sworn in as a special, that was not what was informed to me. I think that that's outside the record.
But you think, I'm sorry, I can't.
The Worcester District Attorney's Office never said that to me. I think that that would be outside the record. When I was sworn in, they...
But you said there's a conflict. That's why you were appointed.
There was a conflict because they, in a different DA's office, by the way, handled the prosecution against Attorney Rubin. And I think that reviewing this in a vacuum, as this court is not necessarily how we should be looking at it.
No, but I'm trying to figure out, the DA's office eventually thought he was guilty of this. They charged him and tried him, eventually. And at the time that this was going on in May, at the end of May already, the DA had said in court that the bailing out may become part of an ongoing investigation and that he thought something very serious was going on behind the scenes. So there's an investigation, serious behind the scenes, and then eventually he says, I think this lawyer was involved. But your position has to be, I take it, that even once you thought it was him, there wasn't enough on this record for him to know that he should be concerned enough that he might have pulled his punches instead of zealously advocating, right?
There's no information in the record that he had any, that there was any involvement of him at this time, other than that they were investigating.
Other than the accusation by the actual prosecutor that he thought he was.
I would not term it as an accusation, other than the Commonwealth is investigating the circumstances of her not appearing for trial, and they have jail calls, and there's a individual on the call that said, whispered, the attorney suggested it, so rightfully so, the Commonwealth looked into this.
So the judge knew that someone had whispered, the attorney suggested this.
The judge had the jail calls,
And
then she
the
found it to be
judge
meritless.
nonetheless said, oh, there's no conflict here. I've looked at these. They say he suggested this scheme, but he's not conflicted?
It's the Commonwealth's position that there's no conflict because there's no divided loyalties where he was not charged with the crimes here. The consciousness of guilt evidence is a separate matter. He requested the discovery. He handled the discovery. He strongly and vehemently argued against admitting it, put up a strong defense on behalf of his client, and the human trafficking aspect is completely separate from the investigation into intimidation of a witness and the circumstances of how this witness was bailed out of jail. They're two collateral matters.
Let me just make sure I understand something, because the phrase district attorney has been mentioned in district attorney's office. So the prosecutor who made the allegation that there was an inference that defense counsel may have been involved in this witness being bailed out, that's one prosecutor's office, right?
Yes.
You don't work for that prosecutor's office, is that right?
No.
Okay, so as a special assistant district attorney, are you a private lawyer or do you work for another district attorney's office?
I'm the Chief of Appeals of the Cape and Islands District Attorney's
Okay,
Office.
Cape and Islands. So it was Cape and Islands that ultimately prosecuted this lawyer, is that correct?
No.
Okay, who did that?
There was a separate district attorney's office that stepped in. I believe it was Plymouth. Then for the motion for new trial, there was a separate district ADA that stepped in from another county. And then I volunteered to do the appeal when
Okay.
I needed an assistant district attorney to handle this matter.
So that prosecutor that kind of got the ball rolling, who made the initial allegation, did he have any role in any of the further proceedings involving this defense lawyer?
Not that I'm aware of.
Okay.
So the motion judge seems to accept as true Cruz's testimony that she overheard the attorney say to the defendant, it'd be better if she were out. Do you agree with that, that we should accept that as true?
I believe that she reviewed the jail calls and found it was meritless, so essentially.
Oh, the motion judge, the trial judge on the motion for new trial.
Yeah.
Seems to recite Cruz's grand jury testimony and accepts the truth of what she's saying.
The judge does accept the truth of what she was saying.
You should accept the truth of her testimony that she overheard the attorney say to the defendant, it'd be better if she were out.
The Judge Wren did, I'd say, accept that, and also accepted that when she testified, she explained her interpretation of that, which was that Beltran here gets an idea, and then he runs with it. And I'd refer to the page 143 and 152 in the grand jury minutes. And she explained that she didn't mean that as the attorney was involved. She meant it as this person, Beltran, would get an idea in his head and then decide, okay, it's better if she's out, I'm going to go and, do something about this. She said she never meant that any of the attorneys were the ones that concocted this.
But wouldn't the attorney then have an incentive not to have that statement that she overheard come out at trial? A personal interest in not having that statement aired at trial?
If you take that statement alone, but there's an entire transcript pages of context as to what she said, she overheard him say it would be better if she were out, and then she explains, I didn't mean it in that manner. and he interpreted it this way, and I should punch him in the face. He's such an idiot. So that statement alone, I can see your point. However,
But he was charged with the crime anyway. It didn't persuade the DA's office.
No.
Okay. No?
There are no further questions.
Are there
Rest
no
on my
further
brief.
questions? Because we went way over on the others. All right. All right. Thank you very much. Excellent argument. Incredible case, actually. We will take our traditional mid-morning break, and we'll return in 10 or 15 minutes to hear the remaining two cases. Good morning, welcome back. We will continue our sitting with number 24156. This, of course, is an impounded case, and people should use descriptions or pseudonyms. Descriptions are usually the best: mother, father, child, etc. I understand that appellees will be splitting their time 9 minutes for DCF and 6 minutes for child. Is that correct? Very good. And we will hear first from Attorney Penta.
Good morning, Your Honors. May it please the Court. I'm Michael Penta, and I represent the appellate mother. Mother admittedly used marijuana, had mental health diagnoses, and experienced transient housing, resulting in extended hotel stays. But the judge's findings and conclusions that her antagonistic approach to and relationship with DCF personnel, sometimes in her daughter's presence, was among the biggest, if not the biggest, contributing factor to her unfitness. But for a case that spanned 4 years, including 12 days of trial and 12 days of trial over 18 months, most of the judge's finding regarding the most serious, aggressive, and egregious behavior, and antagonistic behavior, occurred earlier in the case when the mother was working with social workers she found to be unsympathetic or empathetic to her situation about the sudden death of one daughter and the immediate removal of the other daughter. However, when she was finally assigned to social work in 2020, we see a seismic shift at least in her behavior. She certainly became, as a social, and this is not my words, this is the social worker's words, in summation, that they were communicating regularly, a couple times a month. She was not denying communication as my mother. Their interaction was relatively positive and cordial, and to a point where she felt comfortable enough to remove the police presence restriction. She also found that while my client wasn't engaging in any services, she was compliant and consistent with visitations that were being offered after her assignment as the ongoing social worker. And those findings are not necessarily reflected in the judge's findings and conclusions. The judge's findings and conclusions sort of harp a lot on what happened earlier in the case, which is somewhat frustrating about these cases that last 18 months at trial, because these facts are fluid and they do change over the course of time. And while my client, again, not excusing her behavior at the beginning of the case, seemed to have moved to a more positive relationship, not only with her social worker, but with her daughter. She was engaging in consistent visits. That's what the social worker's testimony is, that the bonding and the comfortability of the daughter seemed to improve over time. And that's oftentimes how these cases are. It's not oftentimes how you start, but really how you finish. And I do submit to this court that it is somewhat of a unique circumstances, because the DCF intervention started because of a report of mother's marijuana use from the hospital, then shifted to an issue with her transient housing, resulted in her removal because of the tragic but accidental death of one of her daughters. And in between that, I think, was also reflective of that mother was, again, engaging positively with her social workers up prior to the removal. She was responded to their calls. She opened up her home, whichever one she was living in at the time. She was up to date with the child's medical needs. And so most of the department's concerns were not reflective, and the department's own testimony was such that, well, there were concerns, of course, with a parent using marijuana and having mental health diagnoses, having concerns, but they didn't see anything troubling or alarming.
That was just a span of 3 weeks, right?
Correct. That's the only window we have, unfortunately.
What's that?
It's the only window we have of her caring for these infant children.
But there was still an open investigation into the original 51A, right? That hadn't been resolved. When you say the only reason that the child was removed was the death of the sibling, there was an open 51A other than the one that arose after the child's death, right?
Well, there was a 51A.
Because of the meconium at birth. That was,
Correct.
but that hadn't been resolved. They were still looking into it, right?
Well, they were still in the midst of an investigation, but there was nothing at that point that would connect that her having used marijuana.
So I was very concerned about this aspect of your argument. about the question of if you removed a child because you suspected something terrible had happened because of the parents to their other child, which is certainly a reasonable thing to do, 11 days later, I think, or less, there's an autopsy that says no, nothing. And if the only reason you took the child away was that, it seems to make sense the child would be returned. But I looked at the affidavit. I think this is the right affidavit. This is from November 8th. So I think that's the day after the child's death. I assume this is for the, to get a court to order the immediate removal of the child. The affidavit says that removal is, quote, due to the family's multiple living placements and their instability in them. The fact that the baby died from reasons unknown, mother's ongoing mental health and concerns of substance use, and then it says, and I'm never really moved by this, and the parents haven't been cooperative with the department. It says, since the baby's death, we're within 24 hours of the baby's death. So I don't know what to say about that. But my point is, it has more stuff in it than just suspicion about the death.
The affidavit may, but Your Honor, you bring up a good point that the department was in the midst of an investigation into the 51B, who also conducted an investigation. This was the court investigator. And they are appointed objectively by the court to investigate into these matters.
In 2019 sometime.
Yes. It was,
a long time later.
Oh, no, it wasn't a long time. Well, it was.
It's not right then, in any event.
It wasn't right then, but I actually, if it's interesting, on the timeline is that this, it was done, their point is usually thereafter. I forget the exact date. I think it was in 2019. You're correct, is when she filed her report. But she comes to somewhat the conclusion that this was, in fact, motivated entirely by the death of the daughter. And I think the record would bear most of that out, though. While there were these concerns, I'm not suggesting to this court that a report of marijuana use or transient housing isn't of concern, but that wasn't what prompted the department to remove the child, excuse me. It was within immediately following the death. I think the record's pretty clear on that from the supervisor's testimony and her own we call it dictations, but her own reports that find its way into the 51As and the 51Bs about that they had decided to remove the child, not because it was the decision to remove the child was done before they even talked to mom, before they talked to any doctors, before they sent any hospital reports. So that decision was already made.
Why isn't this subsumed now within the trial?
That's the trouble, Your Honor. I'm not ignoring the fact or trying to overlook the fact that could there have been a single justice appeal from a 51A? From the temporary custody hearing. But I don't think it could also be overlooked that the judge's findings seem to focus on a lot of the earlier behavior of my client, and there's not many findings or addressing the ongoing social worker's testimony, who had been assigned to the case probably about a year and a half prior to trial. And she was talking about, not to go outside the record, but it's just my own experience with these, is a lot of these cases are driven by the relationships between a social worker and the parent. There are personalities involved here, and sometimes they clash. And sometimes there's reactions that are unseemly, there are reactions that are not laudable, but they reflect more of an antagonistic relationship between two adults. One's the professional, one the parent. And I'd say in this case, you see, for example, it's not clear on the issue of mental health, whether the judge was saying mother has mental health issues because of her diagnosis that are being manifested because of her aggressive behaviors and interactions, or they're two separate things. If they're two separate things, then I do submit to this court, even if they're not two separate things, I do submit to this court that if they are separate, they haven't really established a nexus between mother's mental health diagnosis and her ability to parent outside of her earlier aggressive behaviors. And if they are separate and distinct, without engaging in any treatment, her relationship with her social worker at the time, for about a year and a half before trial, had certainly shown that that manifestation has largely subsided. And I do also...
She wanted to fire this great social worker.
Yeah, again, there are days, I'm sure, where parents and social workers don't get along. I think a lot of the antagonistic, or even as a social worker herself described, usually followed because visits were canceled, because she didn't confirm the day before. I understand that was a protocol of the department for a parent to do that. My client's position was, well, the confirmation is when you say the visit is. If the cancellation is if I can't make it. There was a lot of that. I know earlier on my client had sort of drew a line in the sand with regards to when the visit should occur, but that doesn't gel with the social worker saying once we've had a consistent visitation schedule, mother was largely meeting it. I think she missed 5 visits in the span of the social worker taking over the case. 4 of them were because of that failure to confirm policy, and I think one of them, my client was sick and didn't want to obviously get her child sick. So the social worker herself said the visitations have not only largely been consistent, but there was no observable concerns with the parenting skills or set, that the relationship with their child, while there is evidence that the child had some reactions post-visits at one point, they have actually become more comfortable and there was a little bit more of a bonding. I'm not saying they were ready for immediate reunification at that point, but it certainly shows a dynamic where the parents were, again, back to the original question, well, not the original question, but one of the points raised is that, yeah, what do? Do you return the child once all of that has subsided? I submit to the court that, the department is charged with reunifying parents with their children. It isn't a game, it's
But
really
what about the judge had a pretty specific finding about the mom having little to no understanding of the child's needs, and there was a reference to a particular incident where she just refused to comfort a crying child during one of the visits. That's heartbreaking to hear that. And isn't that pretty compelling evidence that the judge can rely upon in saying that for whatever reason, whether it's the mental health issues or other issues that the mom is grappling with, she's just not in touch with what her child needs?
I think that there are certainly findings made with respect to my client and having struggled with where the child won the incident. There was a pacifier incident, I believe. There was also another incident where I think she banged her head, and I think that might be the incident you're referring to. And I believe this happened earlier on. As I've said earlier, sometimes it's not how these cases start. It's the direction it's going, how and where they are, at least by the end of trial. And I think the record is that when she was assigned a social worker, the social worker's own testimony is such that, saw my client saying, I had a great visit. Social worker saying, the visits went relatively well, without incident, that, there was no concerns with the parents' parenting skills at that time. And so, yes, parents do struggle. And unfortunately, in these cases, they're only given a little window in which to show their parenting skills. They're given, in some cases, an hour a month or an hour a week. And so along the lines, there will be probably visits that don't go as well. Maybe I'm not suggesting that the child was crankier in this visit, but sometimes the child's are cranky at visits, or sometimes things don't go well, and you're operating and judging by this little window. And it kind of goes back to what I was saying earlier, is that, Judge Rubin had brought up, is that it's troubling that, once the investigation cleared the parents of any wrongdoing, that there was clearly an accidental death, and I'm coupling that with the investigation done by the court investigator, that there wasn't any shift or movement towards increasing the opportunities for reunifications, of increasing visitation, especially with the social worker lastly assigned to the case. So it was essentially in a standstill. And I think part of the problem is that there was an 18-month trial. I understand there's a lot that goes on, there's a lot of parties involved, there's a lot of moving parts in getting these tried, but it doesn't excuse that, or doesn't explain that sometimes these cases, which are based entirely on fluid facts, that over time things do progress. So you're going to have testimony from the earlier social workers in January of 2021, January and February 2021, about, how bad the visits were at that point. And then you have a social worker testifying in September of 2022, how things have gone well since she's been assigned the case, relatively well. I'm not saying they weren't without hiccups. So that's sort of the quandary. I know this court does a very tough job, and so do I. But but largely, I said, there may have been some things along the way procedurally that could have been done cleaner with respect to this case, but overall, what we are dealing with is parents' fundamental constitutional rights to parent their child, and this is a type of case where it seems like an isolated incident, and a tragic one at that. I mean, I can only imagine what the parents would go through who lose a child and immediately have one taken from them by the state, how they would react and how long they would react. But again, it's where they end up at the end of trial. I see
Your
I'm out of
time has
Any
expired.
other
Though if I
questions?
see other questions, I see none. Thank you very much.
Thank you.
Excellent argument. We will hear next from, if I can keep my papers in order, we will hear next from Attorney Gilchrist.
Good morning, Your Honors. May it please the Court, Claire Gilchrist for the Department of Children and Families. We are asking you to affirm the orders of the lower court. The department met its burden here of proof by clear and convincing evidence that mother's defiant and aggressive behavior compromised her ability to parent her child. There was a history of mother's temperament impeding her parenting with an older child, and this was evident throughout this care and protection petition, and it was also still evident at the time of trial, where mother had some outbursts at the time of trial, and the judge had to intervene on multiple occasions. So, this was not an isolated incident that led to the removal, and mother's own behaviors really obstructed the ability to reunify here. The department.
When was the mother appointed counsel? When does that happen?
So typically that happens at the temporary custody hearing.
So November 8th?
November 8th.
Or do you mean the 72-hour hearing?
The 72-hour hearing.
How can a 72-hour hearing be held 18 months after the case starts?
My understanding, it was begun within days of the removal, but it was ongoing for several months.
A 72-hour hearing is ongoing for months?
That does happen sometimes, unfortunately, in the trial court. If there's, could be the amount of evidence that's being put on, the number of witnesses that are being called, or the logistics of the court, the scheduling, the attorney's schedules and the judge's calendar. It's not what we like to see, but it does happen. And I think, Your Honor.
And when does DCF have to tell the mother the reasons for the removal?
Well, those are, certainly the department tries its best to communicate.
That's when they have to tell them. Surely they have to have notice you're removing their child. They must have be told of the reasons.
So, yes, I mean, as far as, is there a regulation? I'm not aware of a
Well, there's a
regulation.
constitution.
Correct. So
But I mean, I'm sure you
so-
have to tell them why you're doing it, and I would think.
At the 72-hour hearing, the department has to put on evidence of why it was correct to remove the
And
child.
so when did it first put on that evidence? 18 months later? Or right at the outset of the?
No, Your Honor, I'm not sure the 18-month period you're referring to.
Well, I thought that the 72-hour hearing, I may not be 18 months, but it took place many months after the removal.
So it took, I believe it took 3 months, the temporary custody hearing, the 72-hour hearing, but it began, if I can look at the, if I may refer to.
I mean, I can look through the appendix and see what.
So
I
it began
don't wanna waste your-
within days of the removal.
And including the filing of something articulating what the reasons were?
Correct. There's the affidavit that gets filed with the
That's the
petition.
November 8th affidavit that I've
That's
referred
correct,
to.
Your Honor. So, Your Honor, you've heard from my brother here, and the main points I'd like to make here are that mother's own actions really were an obstacle here to reunification. That the goal was reunification, and the department was making efforts with the parents. During even that 3-month period of the 72-hour hearing, the parents refused to even discuss it with the department, and the court made findings concerning this. I believe it's finding number 113. So from the beginning, the department is trying to discuss to meet with the parents and talk about how this child could go home safely. And then mother's kind of intransience and refusal to even discuss her action plan just continued for years. And a child, how long does a child have to wait for a parent to be ready to cooperate and work towards reunification? And even, my brother mentioned in 2020, mother did seem to be more cooperative with her social worker that was assigned then, and she was making improvements in her parenting during visits. And, the court acknowledged that and made some findings in that regard. But even with a social worker mom, liked, and she'd been through 6 already, she still at times wanted her to be removed from her case. She still continued in her defiance around the protocols with visits, which, even if it's only 5 missed visits, the visits then were once a month. So that's 5 months of missed time with her child, and she seemed to prioritize her need or desire to defy a department request over actual time with the child. So she was missing on bonding there, just of her own defiance. And then, of course, there was evidence that she wasn't just aggressive with department staff. There was the staff of the visitation center, to the point where that center said, no, we can't work with this parent. And then, of course, at trial with the judge. And then in mother's earlier history, there was history of opposition, defiance in her childhood, as well as with her mother, where she'd had multiple year-long restraining orders. And then
You didn't have an expert testify that she had some kind of, I don't know if adults have this oppositional defiant disorder or anything like that.
there was no expert testimony on that. There was just evidence of that diagnosis during her childhood and that she had been psychiatrically hospitalized. But there was, she did have a diagnosis of bipolar disorder, and there was a psychological evaluation in 2014 that confirmed that diagnosis. There were some recommendations for mother that came out of that she didn't follow. So again, I don't want to rely too heavily on the facts of the prior.
Can I ask you this? It was oblique, but I read the judge to credit that, I don't know if it was a police officer, that's actually sort of what I want to know, that some kind of security officer at a DCF office used the N-word. I read her opinion to credit that.
Correct, Your Honor.
Is that an actual police officer or a DCF security employee? Do you know?
So I believe that was a police officer who was present, not for this family, but for another family that was having visits. But that by the end of mother and father's visit, the department worker had to call on assistance from the officer due to the parent's behavior during that visit.
And would that person be a detailed officer, or it's part of the police's ordinary responsibilities to?
I believe that would be a police detail.
Do you know what jurisdiction the officer was from?
If I may have a minute to look at the findings, Your Honor, I could see
Oh,
which
I
area
can look at the
office.
findings. I didn't think it said what jurisdiction, but all right. I mean, maybe it's in the record somewhere, but
It may have been, because I think that particular visit was either the Fall River area office or the Taunton.
Okay. I'll look at the record if it's relevant.
Your Honors, if there are no further questions, I rest on my brief.
Thank you very much. Very good argument. We will hear finally from Attorney Paquin.
Members of the panel, may it please the court, Nicole Paquin on behalf of the child, who asks that you affirm.
Could you pull your mic down a little bit? Thank you.
I apologize for being so short. Nicole Paquin on behalf of the child, who asks that you affirm the juvenile court's order so that she can remain with her pre-adoptive parents. The child was removed at the age of 3 weeks old. She was 3.5 years old at the time that the trial concluded. She is now 6 years old. She has been with her pre-adoptive parents, who are kin, they're relatives, since June of 2020. So she's been with them for more than 4 years.
When did you last speak with your client?
October 30th.
And she's still in the same placement she was in, or about to be put in, this same pre-adoptive family?
She is in the same pre-adoptive family that she was at the time of trial.
Okay.
So trial began in January of 2021, concluded in July of 2022.
And the department and that family all plan to go forward with adoption by that family?
That is very much the plan and very much the hope.
Okay.
And these are maternal relatives, right?
Yes. I'm not sure it's in the record, but I can explain the relation if you'd like.
It doesn't, I mean, unless you want to know.
Okay. They are maternal relatives, yes. The child is thriving there, and the wishes of the child should be considered, they must be considered, and the best interests of the child are paramount in this case. We unfortunately cannot turn back the clock. We can't go back to 2018 or 2019 and undo what's happened in this case. Instead, we are left with a situation where mother's temperament and behaviors throughout the duration of this case showed her unfitness. She consistently, repeatedly refused or could not prioritize the child's best interests. She did not visit for periods of months at a time, and when the child is a year old or 2 years old, 6 months, 7 months, that's a long time to not see a child. Even after the social worker was changed, I heard counsel's argument, mother's argument, that the earlier behaviors were due to a conflict with mother's social worker. Even after that social worker changed, mother continued to miss visits. And, you know, as the end of trial approached, mother was again missing visits. The summer of 2021, mother missed visits. She even missed a visit that she had previously confirmed and then failed to appear, which impacts the child. So the mother consistently failed to prioritize the child. When she did see the child, she had an inability to understand the child's needs and seemed to focus more on her own anger with the situation and with DCF, and just her general temperament seemed to get the best of her, which impacted her ability to focus on the child. By the end of trial, the trial judge rightfully found that child does not have a bond with her mother, but does have a very positive bond with her pre-adoptive family, with whom she wants to stay. I also just briefly wanted to revisit mother's focus on the removal initially. Mother had the opportunity to file an appeal of the interlocutory order after the temporary custody hearing ended, which concluded in March 25th, 2019, was the end of the temporary custody hearing. Mother did not appeal that order, and so her arguments regarding whether the initial removal have been waived. And here we are, so many years later, with a child who has lived with her relatives for more than 4 years, who have bonded to them, who would be heartbroken if she were removed, and very much wishes that you affirm the court's order so that she can remain with her pre-adoptive family as it's in the best interest of the child. There was no clear error of law or abuse of discretion in this case. The judge made specific detailed findings based on the full breadth of the evidence. And I believe that is all I had, unless you had questions.
Thank you very much. I see no further questions. These are, of course, the hardest group of cases that we see, and we really appreciate all three of you helping us with your arguments. So thank you very much.
Thank you. I'll rest on my
The
brief.
case is submitted. Our final case for the day is number 24-171. This is Cedar House LLC versus Jewish Family and Children's Services. And I gather we will hear first from Attorney Davidson.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Leonard Davidson, and I represent the appellant, Hasseltine House LLC, in this action. There are two principal reasons why the lower court decision was in error. The first and the clearest reason is that the Superior Court failed to enforce a valid contract, and that contract required Jewish Family and Children's Services, JFNCS, to request consent from Brookline Bank prior to terminating its lease with my client, Hasseltine.
You sued for breach of the lease and the servicing agreements, and this is not the lease or the servicing agreements you're describing, it's the SNAA, right?
It had, well, we sued for breach of the lease because it purported to terminate it inappropriately, and we brought a declaratory judgment action on the basis that they had no right to terminate the lease because of this agreement that they had signed that affected.
You're saying the SNAA is in this case on its own bottom, not as something incorporated in the lease or the servicing agreements or informing them, but on its own bottom, that if I look at your summary judgment papers, I will see that you argued it was breach of the SNAA.
Well, it's a breach of the SNAA which amended the lease. In other words,
You view the SNAA as an amendment of the lease.
I don't want to get caught in technicalities, because what I'm saying, Your Honor.
Well, these are rather technical matters, though, right? Which contract was breached might make a difference.
The SNAA was an agreement that was breached, because what happened was Hasseltine, Brookline Bank, and JFNCS agreed that JFNCS could not terminate the lease without prior consent from Brookline Bank. And that was, the allegations are stated in the complaint, and it seeks a declaratory judgment that says you terminated or purported to terminate the lease. You had no right to do so because you signed a contract that specifically and unequivocally said you could not do so without prior consent.
So wouldn't it be up to the bank to complain about that?
No, because
Why is
they
that?
never had a chance. First of all, it was a fait accompli. What JFNCS sent, and this is the critical error in this Superior Court decision, was a notice of termination. There was unequivocal their determination to terminate that lease, and that has been, that's the law of this case, and the judge ignored it. Why is it the law of this case? Because in their answer to the complaint, JFNCS acknowledged that the January 24th, 2018 letter terminated the lease. That was what they did.
Okay, but that's, I think that Justice Hodgens' question is, why couldn't the bank complain that they had improperly terminated the lease without doing this, assuming there was damage from this breach, and therefore they can move out all they like? They got to keep paying the rent, right? I mean, you guys don't care what they do in the place so much as you care that you get the rent, right?
And that's
But
exactly.
the bank didn't do that.
No, the bank did not, because the bank relied upon us, Your Honor. We were in constant contact with the bank saying, we're going to pursue this because.
Was the bank joined as a necessary party?
No, because the bank never missed a mortgage payment. We never defaulted on the loan. We never, even though we weren't getting rent from JF&CS. So, your question is, well, couldn't JF&CS have continued to pay the rent? They could have left the premises.
If the bank had wanted them to, and I'm not sure it could have done anything, they can't unreasonably withhold their consent.
We never got to that question.
Well, I'm getting to it.
So
Why would it be unreasonable? I mean, on what basis could they say, assuming the termination had been carried out properly within the terms of the lease and so on, what basis would they have to object?
They could object if there was not a replacement service provider in place. They could object if the house had been
You think
vacated.
that in the SNAA, the JF&CS is promising to find a replacement tenant to ensure that the mortgage payments continue to be made?
No, you asked me what would have been a
I understand.
reasonable-
So if they are pledging that, how can the bank withhold consent on that basis?
That's a question of fact to be determined based upon the circumstances. So in fact, you're absolutely correct. JF&CS could have very easily said, there is no reasonable basis to withhold consent. We're therefore asking for consent, and if you withhold consent, Brookline Bank, you are in violation of this agreement. They didn't do that, Your Honor. Your question is to the heart of this. They never asked for consent. Had they, and had Brookline Bank denied the consent, would have been a different story. But we never got there because it's unequivocally clear that they did not request consent. They've admitted it. It's the law of this case again. And
I don't understand your law of the case argument.
Sorry?
I don't understand what's law of the case.
the law of the case is that in the answer to the complaint, paragraph 12, JF&CS acknowledged, they admitted that their January 24th, 2018 letter terminated the
As
lease.
of January 31st,
As of
2019.
2019, yes.
Right.
In other words,
So
or earlier,
Why
depending on
didn't
circumstances.
so the bank had over a year to object if it wanted to.
We filed a lawsuit, Your Honor, and that, if that isn't an objection, I don't really know what is.
What are your damages if they couldn't have unreasonably withheld consent? What damages do you have? Unless you can tell me some ground on which they could have withheld consent, they would be asked for consent and they'd be required by law, by the contract, to give it. So you need to have them have a valid reason for not consenting in order to prove damages from this problem.
And if they had not given consent because they said, look, you told us you were going to be here servicing these residents for the term of the lease. Now you're telling us you want to terminate. We can allow you to do so. That's commercially reasonable, but we may need more time. We may need a service provider. We may need to give an opportunity to sell the property.
Did you put in an affidavit from a bank officer saying they would have refused consent so that you could demonstrate damage?
No, we don't get, again.
You got to get to damage, right? You can't, a breach with no damage is nothing.
No, the damage, Your Honor, that was caused, and maybe I'm misunderstanding your question, but the damage that was caused was the entity that took over for JF&CS could not provide the same services that JF&CS did. And it cost us in personnel.
Yeah, but if they would have consented, then the SNAA doesn't help you. They have to have, there has to have been a basis to not consent. Or I hear that you were injured by their leaving, but the question is, was it in violation of, right now we're talking about the SNAA, And it seems to me that unless either they wouldn't have consented or couldn't, or even could have not consented lawfully, then that's not what caused your injury.
Well, the fact that it never got to that point, Your Honor.
Yeah, but you have to show now, right? You're alleging, and it was a breach of contract, and it caused us this damage. And I'm just trying to figure out how not notifying them and asking consent caused you damage, how you could have shown that by a preponderance of the evidence without showing that they wouldn't have consented or that they had a right not to consent.
Because the cases hold that if you do not request consent where you are supposed to, we don't get into this realm of possibility. And in fact,
what case? That's okay.
The Tage case, Your Honor.
Which Tage?
T-A-G-E.
Yeah.
And in those cases, the court struggled with this and they said, essentially, it may be hard to conjure up a reasonable explanation or a reasonable basis to withhold consent, but we don't get to that point if consent is not sought. And that's really, unquestionably, what occurred here. The notice of termination did not indicate that JFNCS was looking for consent or requesting consent or positing any basis for consent. And so the damage, Your Honor, is caused because JFNCS left without obtaining the proper consent. That set into place a cascading series of events where we had to struggle to find a replacement, taking care of the residents of this property who are disabled individuals and dependent upon a service provider to give them care.
Why didn't you just put it in the lease that just put the provision in the lease that the bank had to agree, and that kind of would have been the end of it, wouldn't it? Because that's what the Tage case was, right? Wasn't that in the lease?
It was in the lease, but it was a contract just like the SNAA is. In other words, you're correct, it might have made it easier, but the way these transactions work is you need to find a lender, you need to come up with a lease. In this case, they had a lease, they had a service agreement, both of which were contingent upon my client purchasing the property from the seller and getting a mortgage to carry the payments. And as a requirement, the lender says, okay, and it's not uncommon, we want certain provisions, since it's a single tenant for this whole property, we require that the parties agree to certain provisions, and that's what the SNAA does. All three parties benefited from it, and so that's why JFNCS signs it, that's why Brookline Bank signs it, and that's why my client signed it, because it governed rights that are in addition to those rights under the lease. And you're correct. Had we known that Brookline Bank was going to request this SNAA when the lease was prepared, perhaps it might have mentioned it in the lease, but before Brookline Bank would grant the loan, they said, we would like this document. We gave it to JFNCS. They said, fine. They got rights under it. We got rights under it. Brookline Bank got rights under it. And here we are. It was violated, this contract. And the decision of the court, the lower court, treats it as if the SNA was not violated because, as your Honor's question, they said, well, Brookline Bank could have, changed its mind, said they were not going to give consent, they were going to give consent, but not to use a trite phrase, but the horse was out of the barn. On January 24th, when they sent the notice of termination, they also notified the families. They let everybody know they were leaving.
All right, so let's go to this part, which I think goes maybe to the good faith and fair dealing aspect of your allegations. I guess, so, and I think maybe this is what the non-prompt delivery of the first notice is also about. Your allegation, you don't say this, but what seems to be implicit in it is the idea that this was a scheme cooked up by JF&CS to avoid all of its obligations to try to fill empty places, maybe by telling families even before they filed these things, listen, we're going out of, or not out of business, but we're done here, Right, so if you like our services, you won't be getting them here anymore. And so maybe then they go and file these things. They don't let you know so that you can do something about it, although you had a long time after they did let you know to do something about it. Is that your allegation, that this whole thing is a put-up job? Because I don't know if there's sufficient evidence of that in the record.
So, Your Honor, that's a little harsh in terms of language. I'm not going to say that JFNCS was doing a put-up job, but there was sufficient evidence from which a reasonable person could conclude that they were not acting in accordance with their obligations under the service agreement.
Tell me each of the things they did that was not an obligation.
So the purpose of prompt notice was to allow my client to be aware of a vacancy before it got to be a problem, to understand what was going on that may have caused a person to terminate their residency, to intervene, and to help out at the house to make
In
sure.
August, you got this notice of all 5, I guess.
All 5.
All right.
After being informed.
Did you do an investigation that showed that it was all corrupt?
Well, as it turned out, no, it wasn't corrupt, but services had changed. People had been terminated who were the most responsible for making sure that the house was filled.
And what would you have done had you known in May?
We could have intervened and assured the people that we were going to assist to make sure that everything would be properly.
Did you do that in August?
No, because they had given it to us as if they said, okay.
Well, one of them was from August 2nd, and you got it on the 29th or something.
They didn't all leave, Your Honor. In other words, not all of these residents, when they gave notices of termination, followed through on them. So we did get involved. We did speak to the residents, and in fact, the house has survived, and it's in part because my client has gotten involved to make sure that the residents and their families are satisfied.
Did any of them, is there anything in the record that shows that they were told in some way something by JF&CS that made them file these things?
No, there is not. But to follow through on if you're planning something, you don't leave fingerprints behind.
No, but if what you're planning is to get these people to say they're going to leave, they might tell anyone. But whatever, your time has expired. Okay, thank you very much.
Thank you very much.
And we will hear next from Attorney Green.
Good afternoon, and may it please the Court. Lawrence Green, joined by Dean Elwell of McCarter and English, representing the Applee Jewish Family and Children's Services. What was the main event in the proceedings below, the issue of the construction of the special termination clause in the lease, is no longer an issue. Hasseltine has decided not to appeal that issue. Their decision may well have been because of the very sound reasoning of the Superior Court, Judge Friesen, who ruled that this was an unambiguous clause giving JF&CS a right of special termination, and that even assuming arguendo it was ambiguous, it would have to be interpreted against Hasseltine as the drafter of the clause and given other key extrinsic evidence, including a key email by Mark Slotnick of Hasseltine, which is all part of the record before the Court. The fact that that main event, issue 1 in the proceedings below, is no longer before this Court, not only takes that out of contention here, but it also should color this Court's thinking with respect to issues 2 and 3 that are now 1 and 2. And let me start with the SNAA. My brother said that the notice of termination was an unequivocal notice of termination. You have before you in Record Appendix 199 and 200 a document which is notice of intent to terminate lease. It's right there in the ray line, 4 paragraphs down, which is the operative exercise of the notice. It gives notice of an intention here. If you turn over to the next page, you will see here that this was copied by certified mail. I'm on RA 200 to the Brookline Bank, precisely in accordance with the provisions of the SNAA, which said how notice should be given. And based upon all of that, the Superior Court was correct in saying that JF&CS had this right of termination. Now, the right of termination was to take place on 12 months' notice. During the 12 months, JF&CS paid rent. Hasseltine had every ability to find an appropriate successor. And when I hear counsel complain about the cavalcade of damage that ensued here, perhaps they didn't find the right successor. That's not something that gives them a right to sue JF&CS.
Let's say I disagree with what seems to be your implication, that this was asking for consent from Brookline Bank. It is notice to Brookline Bank, for sure, but it doesn't say, you know, we intend to do this, and therefore pursuant to the clause of the SNAA, we'd like your consent. But I agree with you, they're no longer fighting about whether what the lease requires, and let's say I were to conclude that, in fact, your notice of termination and subsequent termination were in compliance with the lease completely. But there's still the SNAA, and it says you're supposed to ask for consent, and let's say I conclude you didn't. Now what do I do?
Right. You have various bases, Your Honor, to rule that the underlying decision should still be affirmed, including the following here. One, there is no provision in the lease that says a breach of the SNAA is a breach of the lease. Your Honor, you were asking my brother about his complaint. You would be hard put in the complaint to see anything there. There is, and you'll see this at RA 142 to 144, a 3-page, very extensive default clause in the lease. Almost everything under the sun is a default under the lease, but for nothing referring to the SNAA. I think you were getting at this, Justice Hodgens. There is nothing there on this, even though Hasseltine, as the drafter of the lease, could have easily put that in there. So that's one major reason, Your Honor. The other is, of course, the issue of damages here. There is no damage that Hasseltine could possibly complain of here, even if there's a breach of the SNAA. Now, it is instructive on these lines that we took the deposition of Mr. Jossam, the 30B6 representative of the SNAA. He testified very clearly that the SNAA doesn't supersede the lease. He testified very clearly that the SNAA was for the benefit of Brookline Bank as mortgagee, and that's what SNAAs are about. SNAAs are documents which really talk about what are going to be the respective rights of the lessee and of the mortgagee in the event of a foreclosure, in the event of a default. Hasseltine, to its credit, has always been servicing this mortgage. We've never been in a foreclosure situation, so the SNAA, the entire purpose of the SNAA never would have become operative. So to get back to your question...
Well, but you didn't know that ex ante.
Excuse me?
You didn't know ex ante that they'd have the wherewithal to do that, right? At the time of the termination, you didn't know, right? I mean, that is how it turned out. But maybe you didn't know that, and maybe the bank wouldn't have known it. Let me ask you this. Under what circumstances can the bank deny consent?
The clause in the SNAA was very clear that it could only deny on a reasonable basis, that it could not be withheld unreasonably here.
Okay, what are a possible reasonable basis?
I think the notion here, Your Honor, that if you're giving 12 months' notice and you're continuing to pay rent for 12 months and you're letting Hasseltine find another creditworthy tenant in the meantime, it is hard under any circumstances to suggest that that is not, that would be reasonable for the bank to say we're going to withhold this.
I understand that maybe it would be unreasonable to withhold it here. I'm asking what's a reasonable basis to withhold consent?
You know, we could surmise some situation, Your Honor, where If in fact there was some notion here that there was a question about the validity of the underlying termination, but we don't have that here. In fact, we have the underlying termination no longer being in play and conceded by Hasseltine in this case.
Let's say you follow the terms of the lease to the letter, and it was also clear from financial information known to the bank, to you, and to Hasseltine, that they would be unable to continue mortgage payments and foreclosure would follow. Could they withhold consent if they found that?
I think that that may have been a question, Your Honor, that perhaps could have been litigated had the bank, not Hasseltine, had the bank wanted to litigate that. I think it still would have been on the losing side. But what I find interesting was a statement that Mr. Davidson made that Hasseltine was in constant contact with the bank throughout. So not only did they get the certified letter from us putting on notice as to something that was going to happen 12 months in the future, but apparently Hasseltine is in constant contact with the bank.
Yeah, but
they knew about the litigation.
I guess you're talking about damages or whether they would have withheld consent. I'm just trying to figure out, it's not a notice provision, it's a consent provision.
Yes.
So there must be something that would be a reasonable basis for withholding consent, or you don't need a consent clause at all if you have to consent no matter what.
I agree, Your Honor. It is a consent provision. What I'm unable to do, Your Honor, is really to speculate on what would have been a reasonable basis. I certainly am saying that what you have on this record would not have been a reasonable basis when there's 12 months given and you're paying rent throughout.
Well, I mean, I just don't know. I'm surprised. I would be surprised if a reasonable basis was, we're going to have to foreclose now because you're terminating. It seems to me like if you complied with the lease, then, and it happened to turn out that Hasseltine couldn't pay the mortgage and there would have to be a foreclosure proceeding. I still don't, under your theory, I don't see how they could refuse consent. You've done nothing wrong. Right, they knew who the mortgage was. You're not on the mortgage. You're not a guarantor of the mortgage.
Exactly, Your Honor. And frankly, Judge Friesen hit on this point in her ruling. She said exactly that. There would have been no reasonable basis.
But I'm just trying to figure out then what is the point of this if it doesn't actually protect the bank?
I think, Your Honor, there could be situations in which it would have made a difference. I'm having a difficult time coming up with one of those hypothetical situations now, but I know on this record.
It seems to fit more comfortably into the situation of an amendment or a modification of the lease, right? Because it says they need the bank's consent to amend, modify, or cancel and terminate.
Thank you, Your Honor. I think it is fair to say that that very clause not only related to termination, it also related to modification.
It's hard for me to imagine a reason to withhold consent to termination independent of the lease itself.
Thank you, Your Honor. And yes, one could imagine that there could have been amendments to the lease that the bank very much would have cared about. So thank you. I think that is maybe the reason why that is there. I just don't know that personally.
Let me just jump ahead to the second issue. Because this had some appeal from my perspective. It seems that the tenant here was concerned that what happened here is we had the notices that came in over a period of time from the family members saying that they were terminating. And it seems that these were, instead of forwarded immediately, that they were held for a period of time. So if there's something to that, there's not an opportunity to go back to these family members and say, hey, let's look at what your concerns are, and we can work on this, and we can remedy whatever the problem is. If it's all held at once, it prevents them from doing that, but perhaps more importantly, it creates sort of a pretext to invoke this provision in the lease about termination if now you have a fistful of these notices, now you've got 5 of them all together. It almost seems like that was being used as sort of the hook to get out of what had turned into a business relationship that was no longer of interest.
Just so it's clear here, Your Honor, the 5 notices were May 30, July 3, July 7, July 30, and August 2 of 2017. They were all delivered as of the end of August. So I don't know that we're talking about an undue delay here, but
wouldn't they just be forwarded right away? Especially where if it's like an email notice, isn't it easy to just say, oh, okay, under the lease, we've got to send this right off?
They weren't email notices, Your Honor. I understand that they were not given right away. There was a slight delay as I've outlined the terms, but let me make this point, Your Honor. The record is clear from Mr. Rouse, the 30B6 representative of Hasseltine, when in essence asked what difference would this have made. He testified that in the entire history of the lease, which goes back to 2013, Hasseltine had never found a tenant. They had never found a tenant. So when my brother is saying here, well, we could have done something in the ensuing months here, they had no record whatsoever of having ever done anything here.
And am I right that there was no...
There's nothing on the record to suggest that there was that these notices were in any way illicitly procured. To the contrary, it's a matter of record that everything was totally above board. So the only question then, Your Honor, is was there a delay? And even if one could say that the dates that I outlined were not as prompt as they could have been, there is no damage to Hasseltine here when they never found anybody. There's also a further point here, Your Honor. As of January 24, 2018, when JF&CS gave notice, Hasseltine had never given notice of a breach. Never. And that is important here because there was in the lease a cure right that would have given JF&CS 30 days opportunity to cure something, even if it was a breach there. The fact that Hasseltine never gave notice of whatever this delay was here, I think totally undercuts any claim that they may have on this appeal.
Your time has expired, but it's a little bit complicated, so if there are further questions, I see none. Thank you both very much. Excellent, excellent arguments and very helpful to us. The case is submitted.
Thank you, Your Honor.
And having reached the end of our session for this morning, I'd like to thank the court staff and court officers for their assistance, and we stand in recess.